No, that was one thing I was going to mention before you start. We have yet to get the equipment in for the timer, so we're using the old-fashioned method again. When you get to 3 minutes, I'll hold up a finger, and then when you're done, I'll motion that you're done.
Yes, sir. My name's John Ashley. I live at 26 Christiansburg, Virginia. And I am here to request legislative reform to the family court system and law enforcement response to crimes committed in the family court. The reason I always begin these talks talking about Montgomery County becoming a 2A sanctuary is so that you can't say you can't do anything. I'm giving you an example of another time the state was told to shove off. I had planned out how I was going to tell my story, but the death of Chad Reed happened, so I wrote the Chad Reed law for the last meeting and threw my story out of order. So if we can go back to November 22nd, I was talking about the Sheriff's Department's policy not to investigate an abduction if perjury was committed in the commission of the abduction, one felony canceling out the other. The sheriff was in attendance and heard what I had to say. He had a chance to correct the record, but he did not take the opportunity. Maybe everything I said was accurate. I would like to tell you what happened when you repeat this policy. A guardian ad litem is a lawyer assigned to be a neutral party only concerned about the child's best interest. My child's custodians had told me, since the court order told me my visitation started at 10 on Saturday, but I worked until 2, I couldn't have it. Since the custodians had questioned my mental health to the guardian ad litem, so I called him because this is how they treat me. I told him, hey man, they stole my kid, tell me to move here. They do this with no repercussion. How would you feel if your kids were kidnapped, but the kidnappers changed their mind? The guardian ad litem goes to the sheriff's department and says I'm threatening his child. They tell him I didn't. It would have to be something specific, like Tuesday at 2 o'clock at the park. But they still bring the lawyer to my house, let themselves in, and interrogate me. Everyone gets to hear my side of the story. Another chance for the sheriff's department to be crime fighters, but they chose not to. The guardian ad litem withdraws from the case, and opposing counsel writes a motion saying that I had threatened him. Now, this motion was signed under the penalty of perjury. So either the guardian ad litem supported perjury, or the opposing counsel did it on their own. Both is felonies. I complained to the Bar Association. They don't dispute that the lawyers lied, but they can't do their job unless they can lie. That's my Fifth Amendment right to a fair trial. The neutral party looking out for the best interest of the child can't do his job unless he's allowed to lie under oath. That's another example of the best interest of the state law, because if the state allowed a fair trial, they might lose out on a chance to charge money for child support. Social Security Act, Title IV, matches what the state collects in child support in federal funding for the state for general use. When I asked the Sheriff's Department for a multi-county grand jury for this case, I was told that me repeating their policy is, quote, a veiled threat. If it's okay to do it to me but not okay to say it, this policy needs to end. Please pass legislation to reinforce parental rights of parents in Montgomery County. Thank you.
Thank you, sir.